We are all here because of both a shared interest in the subject matter and shared admiration for Professor Ronalda Murphy, who is our Lewtas lecturer, but also our Lewtas visiting professor this academic year. And I think it's fair to say her presence has been felt, and certainly by the classes who've had the good fortune to have her as a professor. And it's good to see those students out in force, and of course other faculty members and community members. We're especially honored to have Jody Lewtas and Amy McFarlane as representatives of the Lewtas family here as well. And this is one of the lecture series and visiting professor series that has really been an anchor of Osgood's research culture really for a generation. The professorship was established in 1975, I think it was, to honor James L. Lewtas, who was a graduate of the school, chairman of the Board of Governors, and the combination of both that support and membership in the intellectual community of York University and within Osgoode Hall Law School is something very much embodied in this joint initiative. And we're also grateful not only to the Lewtas Fund and Osgood's funds, but also York campaign funds that all created the endowment that allows us to continue to bring together wonderful crowds for great talks by innovative thinkers. And that is certainly the theme for this professorship and this lecture. And often there are legal and policy, commercial issues that all, again, swirl around concerns about the Charter of Rights and how litigation under the Charter is shaping so many areas of Canada's social, economic, and political life. That's been in the news a fair bit this last week, and Ronalda will be talking about cases not quite from the last week, but certainly from the last year or so, and in ways, again, that are linked together around the theme of the rise of facts and demise of norms in charter litigation. So let me, again, with great thanks to the Lewtas family and acknowledgement of the reason why we come to honor James Lewtas in this way, let me say just a word or two about Ronalda Murphy. And again, she's someone who I have to keep reminding myself is not a full-time member of the Osgoode faculty, because she certainly seems like it, is valued like she were, and from my standpoint, having co-taught two different classes with her over the last few years, it's been an absolute pleasure to welcome Ronalda Murphy to Osgoode, especially in this more formal way this year, because she's been not only teaching and mentoring and working with colleagues and students, but also really giving a shot in the arm to every course she undertakes, whether legal process or evidence, state and citizen, or any others that we throw her way. But she is actually on the full-time faculty of the Schulich School of Law at Dalhousie University, and is a rock star there when she's not being a rock star here. And then if that bores her, which is hard to believe, she has a third job on top of that as special counsel to the Assistant Deputy Minister for the Attorney General in Ontario, and in that role has had her finger in a lot of very important pots around policy, responses, litigation, and seeing again the work of the Charter from multiple perspectives, at least over the last several years that she's been in Ontario, and holding down that perch in addition to her academic first loves. Before all of these academic posts, she also had a really interesting and varied legal career, both as a clerk at the Supreme Court of Canada, as a lawyer at, I think it was Stikeman Elliott, working in South Africa, working in other parts of the world and parts closer to home. I would be remiss if I didn't mention Prince Edward Island at some point, because it is such a a live and ongoing anchor to Ronalda's world and where she grew up and where she has a sibling or two still roaming around. So she'll tell you more of the Ronalda Murphy story as she goes, because she infuses her passion, her curiosity, and her convictions in everything she does. So with apologies for the delay, hopes that everyone did get food, now has space to stretch. Welcome to this edition of the Lewtas Lecture. Welcome to Ronalda Murphy, and please join me in asking her to come to the podium.
Okay, so just to be clear, you're all here by compulsion, and I'm glad that I was able to coerce you. Thank you very much to the Lewtas family for endowing this visiting professorship. It's been phenomenal for me to get to teach all these really cool people and to hang out once again with Dean Sawson, who is one of the nicest people I've ever met, and got that Midas touch, touches things and things get done. And I'm very glad that he took me on as a thing to get Ronalda here, and let's see what we can do and have some fun, and it's been a real joy. I also want to thank someone who's not here, which is Sheila Tucker, who was a drinking buddy of mine when I did my doctorate at Harvard, but is also a really smart litigation lawyer, and she's co-authoring the paper that we're writing on the talk that I'm giving today, so sorry, I don't quite know how to order Lauren to do things, so this is new for us. Oh, we're not there yet, sorry. Yeah, so Sheila's name is on there, and when the paper's ready for publication, I'll talk to you about it. So what am I going to do today? The title is deliberately provocative, the demise of norms. That should signal something like the fall of the earth for lawyers and legal academics in particular. I mean, my goodness, if we don't have norms, if we don't have values, if we don't have shared commitments about what the legal system is, then are we not just in chaos or nihilism? But, just as you head down that existential agony, I tried to bring you back up with the rise of facts. Now, for most academics, facts are almost irrelevant and of no comfort whatsoever. But I want to argue today that facts are actually where the action's at, and in fact are inextricably tied to norm generation in Canada today. I will concede facts didn't matter very much for most of the first 30 years of the Charter's jurisprudence, but I want to assert that that is no longer the case, and I want to introduce a new concept that I think is relevant to how we imagine constitutional law and legal processes and fact-finding in relation to norms. I want to begin today with my mom. Q to you. All right. So my mom, this is a picture of my mom a couple months before she died, which was just a few months ago. And she had a set of norms, and I'm just going to start with my mom's norms because they're not that different from anything else I'm going to say today. I'm just going to use a bunch of legal words. So mom's norms were never go up the stairs empty-handed. So I was one of 11 children. There was always a stairs. And the idea that you could be so self-absorbed and not think about others' needs, that even if it wasn't your stuff on the stairs, take the stuff up the stairs. Imagine what somebody else needs to get done. And if you're going there anyhow, it is no cost to you to take stuff up the stairs. Now, I actually think that basic principle of anticipating the needs for others and asking yourself, does it cost you anything to meet them, is a fundamentally important principle about constitutional law. But it's also one that is pragmatically relevant in everyone's life. There are many versions of don't go up the stairs empty-handed in each and every one of our households, and I'm sure you can think of your own. Another one of Mom's principles was each of you is unique and deserves to be loved for just that uniqueness. She had 11 children, and we are always kind of puzzled that she made us feel unique, because that seems almost impossible to achieve. But her point was, yes, we're the same in the sense of we're all her children, but we're so different from each other. And her commandment to us going out into the earth was, whoever you spend your time with, make sure that they are responding to you in your uniqueness. And that is more important than anything else. So that was, in a sense, her argument for attending to difference and to understanding the significance of the fact that, even though I was one of 11, I was, in truth, utterly different than the other 10, and as they were different from me. We were all going to write our own stories. We were all going to live our own lives. And we were going to have this common ground, but we were going to have different trajectories. And we did. And Mom's third one is an old Irish blessing, which is a bit of the way Irish stuff comes at you, which is it starts out nice and then it gets tragic. So, not a single soul is better than you, and you are not better than a single soul. Which was her way of saying, don't get too uppity. It is true, you should hold people to account, and especially hold those to account on the basis of their alleged superiority over you. But don't make the mistake of thinking you're better than anyone. You're not. So those are, in a sense, my argument will be fundamental normative principles. And I don't think those really ever change. And I'm going to assert today that there are some equivalent constitutional principles that are really not fact-driven, just like these aren't fact-driven. But the new constitutional arguments that we're seeing in our courts in the last 3 years are very, very tied to facts. So I want to turn to those cases in a minute. Go ahead. So we're all familiar with the sources of Canadian law, and the most important metaphor of Canadian law is, of course, the notion of the living tree. Now, this is actually a painting by my sister. I asked her to draw me something, and it took her like, I don't know, a few minutes to paint this beautiful tree, and I really love it. But I said, it may not be like that, Lisa. Do you have another tree that you could draw? And she drew the next one. And I said, that's actually good, because just because it's a tree doesn't tell us much about what kind of tree it is. Is it flourishing? Does it have enough nourishment? Is there enough light? Are there any leaves growing? Is it sort of dead on its feet? And what I want you to think about is, when I come to the end of my talk today, what kind of tree are we growing in Canadian constitutional law? Is it a tree that can sustain itself over time? Is it a tree that gets enough nourishment from relevant facts and norms? Okay, so that's the image I want you to think about as I go through these remarks. Okay, my argument is, if you look back at the first 30 years of charter jurisprudence, you'll see, by and large, and this makes logical sense, the first 20 years are mostly gigantic normative cases. And I know some of you detest those cases because they're Dixon decisions or the Mayor decisions, and they are 50, 60, 70 pages long. And they start out with that same structure and framework, and there's this history lesson and this philosophy debate, and then there's the comparative piece. And it's no longer just common law jurisdictions. Now we've got Germany and India and South Africa, and it's exhausting. And what's going on in all of those cases is the courts need to justify itself as an institution with significant and new power. So how do you justify yourself? You offer reasons. You persuade. What's the court doing? It's persuading us as members of the community that it earned the capacity, it deserves the power that it's been given. Now, simultaneously, the court always says, we didn't ask for this. We were not consulted. The community chose the charter, and they chose us as the institution to resolve disputes under the charter. The community, we the people, gave the last word to the judges. But, that's never persuasive enough, right? That doesn't work unless the court is perceived to be a legitimate institutional actor. So these early decisions are very much the court telling us why they can be trusted to get the norms right. And there's so much philosophy, and there's so much history, and there's so much comparative, because really, we're not making up anything new. When we decide what equality means, really, what did we decide? We decided not to follow the American jurisprudence and do something less disastrous. When we decide what freedom of speech means, we spend forever debating whether or not the German approach or the British approach or the American approach was the right approach. Pages and pages. In Big M, it was about freedom of religion. The religion wars in England occupied pages of the decision. Why? Because we can only understand freedom of religion out of the conflicts from which it was born. And substantive due process, where the court said, you know what? We're entitled to look at the content of law, not just the process, the content, in reference to section 94.2. But I wonder if any of you remember the facts in any of these cases. Probably not, because the facts actually didn't matter much. Any set of facts would have worked to generate the jurisprudence, the normative struggle and articulation of reasons in the court. Now that makes sense. These are decisions of first instance. And it's important for the court to show its power and strength, and it did so. In another set of cases, these are the tree root cases, what I call the structural cases. Structural cases are cases which defined the parameters or the home in which debates about rights can occur. These literally are the preconditions to debates about the meaning of rights. You must have separation of powers. You must have independent judges. You must understand, as weird as it is, Parliament is its own world and the Charter does not apply to it. You have to understand the role of the court when the executive asks for an opinion. And some cases are structural in nature. Prisoner voting rights, which split the court, where the majority of the court held that prisoners must be given the right to vote. That's a structural case because it says the majority does not get to decide who's in the conversation of democracy. It's defining who gets to sit at the table. And the many cases on the basic interpretive doctrines. And again, in none of these cases do facts matter. Yet each and every one of these cases is pivotal to our ability to have a conversation about norms in this country. These are critically important cases. Not that they're cases that didn't divide the court. Of course they did. They were good dissents. But do you understand what I'm saying? That these are foundational cases. They create the conditions for disputes to occur. Okay. Now, what I want to do, before I introduce the three cases and the new concept that I think is relevant, I just want to remind everybody of these three concepts. First, apart from constitutional law, and in part some of constitutional law applies here too, what does law do? Well, the substantive law, contract, tort, whatever, securities, it doesn't really matter, corporate law. The content of the law reflects choices by the community about what conduct is going to be conduct for which legal rights or responsibilities or liabilities attach. Different topics, but it's all about what triggers legal rights, legal responsibilities. And inside each one of those substantive areas of law is a choice about how to decide whether conduct crosses the line into liability or not. Evidence law is about the allocation of risks of error, of truth. So in a criminal case, we allocate the risk of error to the community. We say someone can only be convicted upon proof beyond a reasonable doubt. So if there's a reasonable doubt, the accused must be acquitted. So the risk of making a mistake, let's assume the accused is in fact guilty. And thus we have potentially allowed someone dangerous back into the community. The risk of error is in the community. They will suffer the consequences. The idea here is that on balance, it is far better for the community to absorb the risk of error in a criminal case than it is for any individual to ever be wrongfully convicted. The hit we take to the community from wrongful convictions far exceeds the hit we take from 100 improper acquittals. That's the underlying rule. In civil cases, the risk of error is different. Default rule is, unless the plaintiff can prove their case, as more likely than not, 50% plus one, things stay as they are. But if the plaintiff can prove their case to 50% plus one, legal consequences attach. The risk of error, then, is different. The risk attaches differently depending on what the interests are at stake. Finally, procedural law. Well, procedural law, as you all know, because you've either taken legal process or you're in it, is the law that tells, well, what actually is a legal dispute as opposed to something else? And how do we resolve legal disputes? What's the right process, the proper process for resolution of disputes, given that we can't afford perfect knowledge, even in a criminal case? The standard is lower than perfection, but we sure can't afford it in a civil case. It costs money. It takes time. So our decision about what's the right process is not perfection, ever. It's not even ideal, ever. It's what choice should we make? How much process is required for the community to accept an outcome as legitimate? Now, in this, there are no facts. These are principles, these are the normative principles that are threaded through our legal system. And I want you to just keep those in mind as I present these three new cases. Okay. All right, so the concept that I think that is motivating the new cases is this. When I say facts are doing the heavy lifting in contemporary charter litigation, what I mean specifically is litigants are trying to generate the conditions for empathy. Litigants in the cases that I'm going to talk about know that they will lose their case if it's just on principle. They know that logic has its limits and that they're asking courts to go just beyond their comfort zone. So what allows a court to go beyond its comfort zone? What allows a judge to feel like, no, this is worth doing? And my argument is the concept that's doing the heavy lifting from the facts is empathy. So this is a typical definition of empathy. The cognitive skill, just the capacity, the knowledge skill to take the perspective of another, and the capacity to feel that other person's emotions. So there are two groups of people that don't have empathy. One is sociopaths, and the other are some of those with autism may not have the capacity for empathy. Everyone else does. So what do I mean apart from the definition? Well, metaphors help. One way of saying it is metaphors such as the ability to walk in someone else's shoes, the ability to see through somebody else's eyes, the ability to feel another's heart. It's a very bodily idea. And that's because it's only empathy if you are actually feeling what the other is feeling. If you just feel sorry for another, your emotion is sorrow. That's sympathy. Empathy is more painful. It brings you in. It turns out empathy arises very early. Maybe we beat it out of you in law school, I'm not sure. But you all probably had it, because I don't think there's any sociopaths in my class. These are two nephews of mine. Seymour is the little baby, and that's his brother. And I don't know who's looking more empathetic. I think Seymour is actually looking that he feels empathetic for his older brother. Seymour's a very sick baby, and his brother is worried about him. So Seymour is about 12 months old there, and his older brother is about 3. And it turns out our capacity for empathy starts very young, and we retain it. And it's distributed among the community in more or less, believe it or not, like a bell curve. So people have different ability, but the vast majority have pretty good ability. And you can learn it. There's cognitive behavioral therapy designed to help people who don't have much empathy. But it's something that I'm going to suggest to you turns out to be really important in understanding constitutional law, even though we never talk about it. In fact, when I did a computer search of the frequency of the term empathy in Canadian constitutional law, I came up with 2 cases. in the last 100 years. Sympathy, by contrast, I came up with probably 60 times. And always the following structure: you are not allowed to use sympathy in deciding the case. Or, as much sympathy as I feel for X, I'm going to rule against them. So sympathy arises as a negative, don't feel it. Or this sort of bullshit, as much as I feel it, I'm not going to do anything. And empathy is non-existent. So maybe I'm crazy. I'm suggesting to you today that empathy is the most important concept at work in these new cases, but nobody in the legal community would remotely agree with me. At least they don't talk about it. But I like talking about it. This is Ruth Bader Ginsburg, one of the most extraordinary judges of the United States Supreme Court. It's not a very good picture of her, but I was about where you're sitting, and she was up on the stage at a conference my child dragged me to this summer. And I didn't know Ruth Bader Ginsburg was there. And I was kind of, it's like a rock star moment for a legal academic. And I went up to her after, and I was kind of sad because I had just buried my mother. And she looks a bit like Mom in terms of her hands. You know how my mom was 91. 91-year-old women's hands are wrinkled and soft. And she reminded me of Mom. And I just said to her, I've been watching your career as long as I'm alive, and you've been an amazing leader, especially for women and for justice generally. And you remind me of my mom. And she reached out to me and held both of my hands and said, "Did you lose your mom recently?" And I started to cry, and I said, "I did, actually." And she goes, "Don't worry. You'll think about her every day. My mother died 40 years ago. I think about her every day, and I wonder if she'd be proud of me." Ruth Bader Ginsburg worried about whether her mother would be proud of her. She struck me as a very empathetic judge. But it turns out being an empathetic judge in the United States caused political crisis. Justice Obama, on the occasion of Justice Souter's announcement that he was stepping down from the United States Supreme Court, said the following: do you want me to do an Obama accent? I went to law school with him. I could probably do it. No, I won't. Okay. "I will seek someone who understands that justice isn't about some abstract legal theory or a footnote in a case book. It's also about how our laws affect the daily realities of people's lives, whether they can make a living and care for their families, whether they feel safe in their homes and welcome in our own nation." I view that quality as empathy, of understanding and identifying people's hopes and struggles as an essential ingredient for arriving at a just decision and an outcome. I want someone who is dedicated to the rule of law, who understands our constitutional traditions, who respects the integrity of the judicial process and the appropriate limits of their role. And he said that out loud. And that caused a crisis in the United States. This is Karl Rove, but the Washington Times, everybody got on it, criticizing Obama, saying that empathy equals activist. That the way in which Obama used the word empathy clearly indicates that for him to be empathetic is to care about the poor, to care about the disadvantaged. Now, Obama did try to clarify. He did say, well, I'm interested actually in empathy even for the guy that doesn't like black men. Didn't get many smiles. I thought it was hysterical. But so what happened then was the first articulation ever by an American president of the significance and relevance of empathy in judicial decision-making immediately became a massive political liability. How bad was it? Well, you might remember that his nominee, Justice Sotomayor, got into a ton of trouble when she was nominated because a few years previously she spoke at Berkeley Law School, and in her remarks she said, well, I like to think that as a judge, I am guided by the words of a wise Latina woman. So, What did Obama say when of course, Sotomayor was criticized as being, only interested in the point of view of Latino women? Wise ones, didn't really matter to anyone. And this is what Obama was reported as saying at the correspondence dinner. Now remember, this is always tongue-in-cheek, right? The correspondence dinner. He says, after this controversy erupted, "Now the challenges we face are many, and I'll be honest, I don't have all the answers. And when I'm not sure what's right, I often ask myself, WWLD, what would a wise Latina woman do?" I'm proud of my nominee, Sonia Sotomayor. And all those who oppose her, to all those who say there's no place for empathy on the bench, I say this: I completely understand how you're feeling. When you're upset, I'm upset. As a result, Justice Sotomayor backtracked wildly from any notion of empathy when she was at her confirmation hearing. Justice Kagan also disavowed any relevance or appropriateness of thinking about the law through the lens of empathy. And Justice Obama, that'd be funny. President Obama has absolutely stopped talking about it too. Sotomayor said in her confirmation hearings, judges can't rely on what's in their heart. They should only apply the law. Elena Kagan said, it's law all the way down, not empathy for a litigant. Now, I think that's just crazy. Not only do I think that's wrong as in inaccurate, I also think it's wrong philosophically, and it's tragic that the beginning of an understanding of the significance of empathy, a return to facts, has been squandered on the sacrificial altar of Republican-Democrat debates over who is qualified enough to sit on the United States Supreme Court. My argument is that to succeed in a tough, novel claim, the single most important thing that counsel must do is litigate to achieve the goal of having the trial judge feel empathy. I'm going to look at these three cases, but before I do, I want to mention two examples of where that did not occur, and the result was devastating for those arguing in favor of a novel claim. For example, Louise Gosselin, who was the representative plaintiff in a massive class action suit in Quebec on behalf of the right to welfare. Now, you all studied the Gosselin case, so you know that she went down in flames. The majority of the court, Per McLaughlin, had no difficulty saying that there is no right to welfare on these facts. Her entire decision is predicated by the phrasing, on these facts. And she writes a paragraph saying, don't bring these cases. One representative plaintiff, one person's narrative in an affidavit can never be the foundation for a claim for how many million was it? Does anybody remember? $350 million? Disastrous litigation. So too, the Christie case. Christie was an amazing lawyer from British Columbia. He was tragically killed while bicycling across the country trying to raise money for access to justice. He represented the poorest of the poor, the most downtrodden of the downtrodden, in a busy practice in Vancouver. And he brought a constitutional challenge to provincial sales tax for legal services, arguing that if you're poor and it costs you $100, you might be able to gather that. But if you're poor and you also have to pay tax to get your legal services, that's wrong. Again, the Supreme Court of Canada said, there's just no facts here. We don't have any of these people here. We have a lawyer telling us about these people's experience. It's not good enough to ask us to engage in the redistribution of the economy without any evidence of the difficult economic modeling that might be relevant to taxation and legal services. And again, my point is, these are good normative claims, right? Who doesn't want access to justice? Who doesn't want a right to not be hungry? But they are failures of litigation because they produced the opposite of empathy. They produced coldness, maybe sympathy, but not empathy. By contrast, what were strong cases? Chowley, ironically, is a strong case. Why? Because it sucks to be in pain. Pain scares people. Almost anybody of the age group sitting on the Supreme Court of Canada has some in their hips or in their neck. They felt the pain of not having medical services, of having to wait and wait and wait. That's a smart litigation strategy. And these three are also cases where my argument is they were beautifully litigated. Okay, so the first case, if you could flip one more, is Inside. I don't know if you can see clearly. This is a picture of a woman, a heroin addict, on the downtown east side of Vancouver, trying to inject herself with heroin. The argument in this case, Inside, is Scalia's worst nightmare. There is a right of heroin users to have safe injection sites. You think gay rights freak Scalia out? I don't even think you could tell him about this case. I was at a conference with Scalia and I overheard one of my colleagues suck up to him as the way we do in law school sometimes. Oh, it's so nice you're here, you know, you came to Canada. And Scalia said, I don't mind coming here. It's always good to be reminded how bad it can get. I think we should send him this picture. So in Inside, the issue was whether or not the federal government's refusal to grant an exemption for a pilot project in the downtown east side where half of all the heroin addicts in British Columbia live, where 20% are Aboriginal, where almost all of them were exposed to hard drugs as children, where almost all were abused sexually and physically as children, where half of them live on the street. And lo and behold, British Columbia, the police, and the city decided we should do something about this. We got really skyrocketing rates of Hep C. We've got pretty high rates of HIV despite cocktail. And they decided to run a pilot project where they would do safe injection. And that's the Inside case. The next one, you all know, because there is Professor Alan Young in the background, with three of the litigants in the Bedford case, all involved in the sex trade industry. No, yeah, maybe Scalia would actually find this one worse. Maybe he would. And they were successful, as you know, in striking down, Supreme Court of Canada struck down the body house provisions, the communication provisions, and the living off the avails provisions. And I'm going to talk about why I think that case was a brilliant example of how to litigate for a radical claim. And the third case I want to mention is the Carter case. This is Lee Carter. Lee Carter was suffering from a debilitating disease, ALS, and she knew that she would be unable to administer the medication to allow her to commit suicide, which is completely legal, and sought the assistance of a doctor to help her. Yeah, maybe Scalia would hate this one even more. It's a tough call. Which of the three? Okay, so if we could just, here's what I wanted to point out. So how do you resolve these things? Do you have giant trials? Are they philosophy debates? Well, interestingly, in these cases, the procedures used were different in each one. In British Columbia, in the Inside case, this is how they did it. Canada initially did not want there to be a summary trial, which is sort of in between a summary judgment motion and an actual trial. And the case was done on affidavits alone, sworn statements of witnesses. So no actual witnesses were heard by the judge. Amazingly, no objections to the evidence by either side, which meant it all came in, and it was the judge's job to assign weight or no weight to any of the evidence in the course of the arguments. In the Bedford case, this was a straight-up application. So again, an application is when there isn't contested facts. This was contested facts, but they chose to do it through an application, and they did it through a joint record. So everybody got their evidence in. The idea was to put it all before her, Justice Himmel, on a motion, the application motion. In the Carter case, they made up a new procedure. Amazingly, Justice Lynn Smith said, well, let's do a summary trial on some of the affidavits, but there are some people's testimony that's more important than others. I bet you counsel can agree they did. And then they had cross-examinations on some of those affidavits. 2 weeks of those crosses were in front of the trial judge. 2 weeks were just recorded, and then everything was brought back. There were some arguments about some of the witnesses, and there were some objections that were successful, and some of the evidence was ruled inadmissible. But in all three, what really happened, it was left to the judge to figure out what the evidence supported or didn't. And what evidence was there? Oh my goodness. In Insight, 20 volumes, 4,000 pages of evidence, many of which were from users like the woman at the front of the images I gave you. Lots of evidence about actual empirical assessment of Insight's project itself, which had been extensively studied. There were 30 academic studies on whether or not Insight was successful, as well as comparative studies. This is critical. Instead of asking judges to speculate or infer whether or not safe injection sites reduce harm, counsel did not litigate until they had those studies ready. That's smart. The next one is Bedford. You probably know about Bedford from Allen Young, so I'll just be quick. Lot of evidence, 88 volumes. Again, many sex trade workers on both sides, many of those involved in the industry, and lots of academics. On top of the affidavit evidence, we see here the judge pointing out all kinds of other sources of knowledge. And then finally, Carter, there were over 15 lay affidavits. That means people who are willing to say, I assisted my mother in dying. I took my mother to Switzerland. I want to die. Those are lay witnesses. There were also 70 experts. The government in turn put in its lay witnesses, its experts, and as I've noted, some of this was actually cross-examined. What I want to do now is show you how the court dealt with empathy, and my argument is that it was empathy that allowed the court to find the facts necessary to create the norm. It was empathy that allowed the court to reach the startling conclusion that the federal minister for health had to issue a discretionary exemption. They issued an order of mandamus. Now, oh yeah, you're not shocked, but like, you are, right? Like, you never get mandamus. I mean, that's like, forget it. The courts are not willing to issue mandamus. But to issue it to a cabinet minister on a discretionary thing? Wow. What happened? Well, this is what happened. The facts showed, it's the second point that matters, this is not about recreational drug use. This is about people suffering. And the next, the court then said, and they're suffering despite the fact that everything we've done in the past hasn't made any difference. When they come to the safe injection sites, their health outcomes and mortality outcomes improve. And this is the key, number 3, there were no increases in crime. So why exactly did they shut down Insight? Well, it can't be because it was good for the health of the individuals, and it can't be because the community didn't support it. The community did support it, and the scientific evidence was overwhelming that if you care about health, you can't shut it down. Next one. In Bedford, we have a radical new decision saying that when judges at first instance, which is what all these judges I'm talking about are, when they reach findings of fact, the normal rule is their rulings on individual witnesses, of course, get deference. But remember, we didn't have any witnesses in any of these cases. This was all affidavits, right? Affidavits and reports. As a result, this is what we call legislative and social science evidence. And the normal rule was, until this decision, no deference on that. You could do it just as good as the judge. If it's not about seeing someone testify, then the appellate court's just as good at reasoning as is the trial judge. In Bedford, the Supreme Court of Canada changed course completely and said, from this moment on, findings of legislative and social fact are now going to be treated the same as credibility findings. So what does that mean for us? It means that if you're going to litigate a new normative claim, you had better spend your time getting your facts right, because you're going to be locked into them. It's going to be very difficult to overturn any findings on appeal. In Bedford, the court refers to the evidence of the sex trade workers about things they wish they could do. You know, maybe smell someone's breath to see if they're drunk. Call a friend. Write down a license plate number. And then what really, really annoyed the court, and if you watch the oral argument, you see this, they are apocalyptic. That at the very same time that Picton was out murdering sex trade workers, the government insisted that Grandma's house, which was a safe haven for street prostitutes, be shut down. And the court cannot get its head around this. How can it be you care about these women? You say that this is about caring about these women, but you deny them a safe house when there's a serial murderer targeting them. Same as Insight. You say you care about the community, but the community is doing better. The addicts are doing better. So you're lying, right? They don't quite say that, but that's what they mean. And it's only when you can show that the government is actually full of shit can you conceivably get the court willing to be that radical. And the third example, sorry if you could go one more. I don't know how that got there. Okay. There, the Carter case. The key fact that was established in Carter that wasn't in Rodriguez is this one. That individuals suffering from irremediable diseases which cannot be addressed by procedures that they can live with, they choose to end their lives earlier than they need to err on the side of the ability to commit suicide. And it was that fact, produced through many lay witnesses, all of whom said, I don't know, like one day I might wake up and not be able to use my hands. So I better kill myself in January because, if I wait for the graduation from high school of my grandson, I may not be able to do it. So I'm going to take the risk and err on the side of killing myself. And that the court responded to with, why should anyone be made to make that choice? What are we gaining out of inflicting that kind of suffering? You can keep going. The other key fact, and I can conclude my discussion of the cases on this point, is that in Carter, compared to Rodriguez, where the court had ruled against this claim, Justice Smith had the advantage of 10 years of study from other jurisdictions, which tended to support the view that rates of use of physician-assisted suicide did not skyrocket in any jurisdiction where it had been made legal, and there was little evidence of abuse of the provisions. In fact, for example, in Oregon, the people who filled their prescriptions for the medication, let's say there was 70 of them, only 20 would actually use them. That the provision of the potential to use them if need be was probably more important to those suffering than actual use. And that evidence is only available now after a decade of study with Oregon's law, as well as other jurisdictions. So, I don't want to, however, suggest that it's unproblematic, although I don't agree with Karl Rove for the same reasons, to think that empathy is necessarily a panacea. And I don't think empathy necessarily is related to justice. But it may be the solution to indeterminacy. Obama has this great expression where he says, you know, if you're running a marathon in law, the first 25 miles are covered by settled case law. It's the last mile that's indeterminate. It's the last mile that goes up to the Supreme Court. It's the last mile that there's no case law on point and you could justify either outcome. And what he said was, in that mile, I want a justice who's got heart. And the idea there is, given that we could argue both sides in those 5% of the cases, that last mile of the run, should we factor in empathy? Should it be relevant? Should it be important? One of the debates in the psychological literature on empathy is this. Let's say you feel empathy. Does it mean you should act on it? Is part of the definition of empathy that it is something that compels you to do something because you feel somebody else is suffering? Because if there's this inherent causal connection between the experience of feeling suffering and the compulsion to act on it, it may be too powerful for law. It may eliminate other legitimate sources of decision-making. Most people think empathy does not compel us to act. I happen to agree because I feel empathy all the time, but I seem to do very little to actually make the world a better place. So I personally don't think it inherently compels you to act, but it sure makes me wish I would be the type of person my mother was, who always acted, who had so little and always gave. For some people, I think it does make them act, but I think it's debatable. And the most important issue is it tied to the disadvantage? Is the Republican Party correct that when you ask judges to be empathetic, you are inherently putting on the scale of justice something positive for the poor, for the disadvantaged, for the suffering? And is that appropriate? Or can you not argue? Remember when I said, Obama said, well, I was talking about empathy for the guy that doesn't like black men. I think that, in fact, the biggest challenge of our legal system, the biggest challenge we face, is not empathy for the downtrodden, but for the people that cause them the suffering, too. We are never going to change much if we don't learn to empathize with those with whom we disagree and find a way to communicate and persuade each other across those differences. So I think empathy can be quite value neutral. When I lived and worked in South Africa and had to sit down and negotiate with white racist Afrikaners all the time, I actually had to learn to understand their point of view, their fear, their racism. It was the only way I could be effective in representing the interests of the black communities that I was defending. It'll make you better lawyers to be empathetic to all. It can be value neutral. Now the last slide is the limits of empathy. I don't think empathy determines any norm. What it does is it increases the circle of people we should think about and care about on our way to deciding what a norm should be. It is not the same by any stretch of the imagination as solidarity. Solidarity is, I will stand up for you. I will be there. I will have your back. But it is a pledging of support as opposed to an independent decision on your own terms of what you think. It is not sympathy. Sympathy is a flooding of emotions that distracts you from using other things that matter as well, like reason. Sympathy for a victim of a rape. Jurors are always warned not to let sympathy misguide them into finding someone who is not guilty. That's appropriate. It also does not follow that any of the cases I've talked about couldn't have been decided the other way. My argument is simply that they could not have been debated properly absent the factual record. I was shocked when the Inside case came down. I was shocked when Bedford came down overturning the Court of Appeal. I hope to be shocked with Carter, which is on leave now. My point is simply that it may be the necessary condition for new claims. The absence of it may prove fatal. The presence of it is not necessarily adequate. And I'm not saying that we don't get it wrong. There's always that risk of projection. You know, I know how you feel. You don't really know because you stopped listening as soon as you thought they said something that related to you. That sort of narcissistic empathy. That's a problem, right? That happens all the time. And you can just be inaccurate in your assumptions about what someone else is feeling. And I want to conclude with one really important point, that empathy alone, just like law, can't stop tragedy. We can't ask law to prevent all suffering. And we can't ask empathy to become the way we make law stop suffering. Law can't do all of that, and neither can empathy. And so the last image I want to show you, so little Seymour, he died a few months after this picture was taken. Now everything went right. Everybody acted properly. His parents, the doctors, Sick Kids Hospital. But Seymour just never really had a chance. He just had really bad luck. And I can empathize with his parents, my nephew and niece, and his brother, who all miss him terribly. But law can't stop that kind of suffering. That's just tragedy. I'm talking about using empathy to respond to what law should take responsibility for, making life more violent, making addicts die, and making people leave their families before they should have to. That's all preventable. But if you want to make a judge go with you, get your facts. The norms are easy. Thank you. Oh yeah, okay.
So we've got a few minutes for questions, and again, that was a lot of territory covered and some very important but also emotionally compelling cases and perspectives from which to view them. So I know that this is going to be generating lots of discussion long afterwards. But for those top of mind questions, concerns, comments, clarifications, the floor is now open.
That's such a good point. And I was going to put that in there because I thought, how much of this is, gendered, right? because it's Sotomayor and it's Elena Kagan, so we have two women. And, you know, does anybody remember the Carol Gilligan care theory? You know, women have was a dominant theory when I was in law school, but it was the idea that the sort of traditional child's model of justice differs on gender grounds, and that little boys grow up with a very hierarchical model of justice that's not fact responsive, it's very principled and normative, whereas you know, girls and women, we get very hopelessly confused by the facts, and, you know, empathetic everywhere and caring, and it's not principled and it's compromised. And so it made me think of that debate and whether or not that was true. So I think it's a really good point, and I think it's particularly cogent given some of the characters that were really pissed off about this in the Republican Party. So yeah, I think it might well be gendered, but I guess I deliberately left gender out because I don't want what I'm saying to become trapped into that discourse. And I want this to be seen as, I want empathy to be discussed as a necessary condition for litigation, but also as part of what a judge needs to be a good decision maker. And then thirdly, part of what the institution of the court, the judiciary itself, needs to be legitimate and seen as legitimate by the community. Those big normative cases that nobody remembers any of the facts of were important, but if the court wants to continue to be relevant, continue to be important and seen to be adding to the good of our community as a whole, I think it must speak to people's experiences. So I'm a little worried about triggering a gender debate a little bit, because I don't think this is gendered, but I think the politicization of it was absolutely gendered. Most of, you know, some of the judges that lost it on this in the United States were, you know, Calabresi and, you know, some very famous judges, Posner, who are sort of like all over this. You know, I'm a brilliant judge because I'm not empathetic. How dare you suggest that I become weak intellectually? So, yeah. Go ahead. You feel my pain?
I do. And I see your point, absolutely. It's something I've thought a lot about in law school, and I'm kind of confused about too, though, because there's such an aversion to bringing the personal, even if it's just simply empathy, the personal into the law, whether it's a law student or a judge or an academic.
Yeah.
And you look at other fields like social work and anthropology, where the examiner, their personal is central to their examination of whatever it is, so
right.
the subject might be. So why do you think that why is there this aversion in the world of law? Like what is it that's so challenging about being empathetic and bringing a little bit of the personal into your basement?
Okay, I have two answers, one of which is it might come across as a bit of an apology for that, and the other is a critique of it. So those of you who are in my evidence class, right? How many cases have we dealt with that just break your heart on the facts? It's endless, right? It's the worst of human nature, leaving bodies everywhere, violated, ruined, lives destroyed. And I, you know, repeatedly warned you that it's going to be like this, and we could cry every single time, right? And I kept saying, you know, you kind of get used to it. You sort of have to get used to it, right? Like, you can't stand up in court and prosecute or defend if you're devastated by the facts. You just can't function. I had a girlfriend who's a really prolific lawyer, Freya Christensen, who just came off of the inquest into the horrible killing of Jeffrey Baldwin. And she's like crying on the phone, and she won't mind that I said this. She was like, you know, I can't, I just feel terrified by all the horror that I had to witness. And I'm like, get over yourself. Get over yourself. Be a prosecutor for a day, you know? There's one child. Imagine it day in, day out, day in, day out, day in, day out. So part of me wants to say, you just can't feel it all or you'll fall apart, right? You have to kind of be the strong one, right? They depend on you, the victims, the cops, the defense counsel, to keep your shit together and ensure that there's a fair trial. So you don't get to fall apart. That's one answer. So maybe I've trained you all how not to fall apart in evidence law. The other answer is because we're all such messes, right? We're all insecure and threatened by everything. And, if I tell you something personal, will you use it against me? Will you think less of me? Will you think I'm less smart? Blah, blah, blah. It's not a very good answer, right? But, the institutional answer is it's irrelevant, right? I should be able to persuade you on reasons and not anything else. So there's three answers for you. Personally, I think that we, and Lawrence Law School is a good example, we had better start attending to the psychological needs of our students if we expect them to be able to respond to the psychological needs of the community. All students should be trained in the skill of writing an opinion and taking a time out and not losing it and getting therapy when you're scared and not hurting your client. Mindfulness, yoga, eating healthy, not pulling all-nighters. These are all essential conditions to flourishing as counsel. We should be starting now. But I see that there's quite a bit going on here. I certainly see yoga mats in my classes, which is impressive. Maybe we can see the dean leading a session once.
So this isn't on yoga, but it's a related thought that I had in my mind as we were talking about Gosselin, in particular at the beginning. Because there's this sense sometimes of empathy with a vengeance, which is when you're listening to the accounts and you empathize with the mother and father of Gosselin and not Gosselin. And when you read that judgment, there's a clear bonding between the court and the putative parents of this young woman trying to survive off welfare that was acknowledged by everyone to be below the poverty line. But it was a kind of tough love mentality that is not all that subtly
Yep.
underlying the reasoning. So is that empathy too, but gone awry, or is that actually empathy shaping the debate in the way that you envision?
Well, I think that's exactly the debate we should have, right? Because I don't think the fact that Louise Gosselin didn't flourish in the welfare system. I mean, my anger at that case has to do with the fact that I know so many people who would have made better litigants. Like that, I know so many people that have done everything right, that are the ideal recipient and still can't cope and survive because there's not enough. Whereas, the minute she said on her deposition that she quit that job because she was stressed, I would have walked away from the case and said, we need another representative plaintiff. Because that's not a good, I'm going to get empathy from the Supreme Court of Canada because I was stressed? Like, that's fatal to me. It's a fatal sentence. I'm not saying that you shouldn't feel empathy for Louise. I am saying it is part of your ethical responsibility as lawyers to not bring cases on weak facts when the consequence isn't going to be to you. You just lose a case. But to the development of a norm that's now going to be set back for 20 years, 25 years. That's on you. You think Louise Gosselin was giving the instructions in that case? So I'm saying, my call is embrace empathy, embrace the facts, including the tough love part of the empathy conversation. The Supreme Court of Canada didn't freak out when it dealt with the fact that some women choose to be sex trade workers and some don't. Everyone was like, oh my God, we got to win on the choice argument or that's it, it's over. What did the court say? Yeah. So, for the ones that didn't choose it, why are we making it so dangerous? You don't have to have 100% perfect litigants. They're not stupid. You just have to be truly telling the true story in your communities, including the fact that, there but for the grace of God go I, and having a child who I feel I've got to kick out of my home as the only way to make them straighten up.
So maybe one more question.
Yep.
And we'll have to wrap up.
My question, as I was listening to
You know, I'm not hearing you terribly well, sorry. A little bit. I heard we don't create new norms, we something.
I'll speak up. I'm usually afraid to use my voice just because it can feel empowering, but I'll speak up this time. You said that we don't create new norms. I don't think we create new norms, but we just kind of view them differently. And when we look at norms, norms come with emotional content to begin with. When you say justice, it's got emotion that it carries with it. And it's emotion that's built in past generations based on facts in past generations. These are all fact-based things. So I'm wondering if, when it comes to going the extra mile, as Mama said, whether we just need those facts so that we can see that the norm that we value, that comes with emotion, needs to be balanced against the emotion that should be carried with it today that we fail to see because of the presumptions that we have.
Right. Excellent question, and I'm grateful for it because it's an important supplement to my argument that's in the paper, but I didn't present. So, you know, you're absolutely right, norms have facts, right? Like norms didn't come out of nowhere, right? They almost always are the outcome of people's struggle. And you're right that at a certain level of abstraction, there are no new norms, right? Surely my mom's 3 laws, you know, I can generate the whole charter out of those 3 laws, right? Like it's not that hard, right? You know, there but for the grace of God go I. Do unto others as you would do unto yourself. You know, you can get the whole charter out of these basic fundamentals around, unless we're going to kill each other and we need to figure out a way forward, how about we use these rules, right? So sure. But what is interesting is, well, why does a norm get extended, right? What are the preconditions for norm extension? Why were women finally successful in arguing for equality? Why were blacks in the United States successful? Why are some of those struggles still ongoing? A quarter of all black men in the United States do not have the right to vote. That struggle is not going very well, right? There's a lot of struggles that are failing. It's not inevitable progress, and it's not constantly improving, for one thing. So I agree with you about that. But facts also have ideas in them. Right? Just like norms have facts in them, facts have ideas in them. So when I say there's little Seymour, he is suffering, that's not some neutral reality, right? I have a concept of what it means to suffer. It's when you are experiencing pain through no choice or fault of your own. Right? If I'm running a friggin' marathon and I'm suffering, that's not really suffering, right? Because I could stop. But Seymour didn't get to stop. That's suffering. So I've got a whole bunch of ideas even embedded in my capacity to determine what is a fact. So I think the relationship between reason and emotion is one of constant interaction. I don't even think you could really separate it. That's gendered too, of course. You know, the idea that, you know, women are emotional, men are reasonable, or reasoned, or something. But you know, of course they're both constantly, and I don't know any more than that. I mean, maybe that's a compromise, but that's where I fall down on that. But all I'm trying to do is say, at this moment, in our development, in this jurisdiction, at this moment in time, on these novel claims, facts are more important than the norm.
Well, that's the perfect line on which to end this exploration of this journey.
It's an awfully big bag.
It's a very large bag, which carries with it not only tangible tokens of our appreciation, but all the love and affection underlying that affection. So here is a chance